you're about to sign a book contract or you're aspiring to one day work with a traditional publisher, you need to make sure you understand what goes into a good, healthy book contract. And we need to know that publishers and agents will be putting clauses in there that work more to their benefit than yours. So while today's episode does not replace the need for you to hire your own professional publishing lawyer, who is the only person on your team who is solely devoted to making sure your rights are taken care of because they don't have skin in the game like publishers and agents do, we want to break down from a law professor just what you need to know about red and green flags so that you can understand the context of the contract you're reading before you hand it off to your publishing lawyer, who is then going to help you go through it and make sure it is covering everything that you need and there's nothing in there that should not be in there. Let's jump into today's conversation with a law professor as we go over all the details.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram and TikTok account called The IP Professor that is dedicated to all things intellectual property.
And today we're going to be talking all about book contracts, red flags, green flags, things that we should be mindful of, because this is a really big conversation we have in the publishing industry when we get into traditional book contracts. So Tony, I've had a lot of experience with book contracts. I've gone over a lot of them in my day. I love to shred them. I love to look for red flags, and I love that I can negotiate them with the help of my lawyer. It's always important to make sure we've got a publishing lawyer on our team before we sign any book contracts. But let's break down some of these big red flags and green flags that we should be looking for in terms of book contracts. One of the things that comes up a lot is rights grabs. So when publishers are trying to also get the rights to potential movie deals or to our audiobook rights. So what do we need to know about things where they're trying to add in other parts of our book world?
Great clause that I think is under discussed, and I think that it's important for people to understand that as authors, you have, and you've created these, manuscripts, these works, you have rights that you should exercise. So instead of treating publishing agreements as like a all for one type of deal, it might be best as kind of like a way to avoid doing rights grabbing, to have an initial publishing agreement that just addresses the publishing aspect of things. And, you get an advance for, submitting a manuscript, you work through drafts, you get another advance, so on and so forth. And then there's obviously discussion in these publishing agreements about royalties for every units that are sold of a book on, X platform, what have you. If there's a lot of hype from the publisher that they really want the film rights as well, or they want to develop it into some other type of media, if you will, then I think the best strategy would probably be to create some type of clause within the agreement that would create an option. So that way, at the very least, if they decide to pick up the book for, let's say, a film series, or even just a television show series, at the very least, you guys can have a separate discussion about that type of point, and it's not already pre-negotiated. Because what if the book does insanely well? What if the book flops? What if the book does mediocre and you can't get out of it? It becomes basically a massive mess. And I think the best example to use for something like this is J.K. Rowling with the Harry Potter series. J.K. Rowling created an IP empire with Harry Potter, not just with the characters, but just the houses of Hogwarts itself, but to the point that they could service their own trademarks. Now the question becomes, imagine if J.K. Rowling had worked with Scholastic and lumped everything into that. She would not be the billionaire that she is today. She was smart in just addressing the publishing aspect of it with Scholastic. The book series did insanely well. And then in came walking Warner Brothers and said, we want to develop this into a film series. That happened. Then in came Universal. Let's turn this into a theme park attraction. I mean, bottom line is she staggered all the licensing out, if you will, of the franchise. So I think that that's important for authors out there watching this. Don't lump everything into one agreement. Have each right or every license that you're trying to seek its own separate governing document. Don't lump it all into one, unless they're giving you a crap ton of money. Then if they are, go for it. But tread very lightly.
And I think one of the things that I like to talk about most when it comes to contracts is that we do have the power to negotiate. We don't just have to accept the boilerplate contract that they offer to us. So we have the ability to take things out and add things in and make requests until both parties are happy. Because for the most part, when a contract is created, it is created by the publishing house's lawyers in favor of the publishing house and not so much in favor of the author, which again goes back to why it's so important to make sure we have a publishing lawyer on our team, as they are the sole person who is solely on our side. And so, with that in mind, we do have the ability to negotiate. What should we know in terms of how we are able to negotiate those contracts?
I think the most important thing to say on the from the onset is don't think that negotiations is going to kill the contract. I think a lot of people are quick to say, well, I don't want to ask the question because I don't want them to back out of the deal. The essence of contract law is about a meeting of the minds. This is what is taught to every law student when they enter law school and they take their first year contracts course. Contracts inherently are about a meeting of the minds. Both parties, one with one vision, another with another vision, entering the bargaining table and fleshing out the terms and the details so that, yes, there may be bickering and back and forth, but at the end of the day, both parties are content with what is ultimately negotiated and bargained for. And, again, negotiations have to have that type of banter back and forth. And at the end of the day, if there is a publisher that is so intimidated by your negotiations that they back out, then frankly, they shouldn't be in business, because that is how contracting happens today.
Yeah.
That is how every type of negotiation happens, whether we're talking about a negotiation on a foreclosure, a negotiation with respect to photo and video licenses, negotiations for music licenses, even down to negotiations with car dealerships. I mean, that's how it goes. So bearing in mind that that it's okay to ask these follow-up questions and make comments like Cam is saying, you have rights. Your publishing lawyer wants to ask these types of questions. You want to ask these questions, go for it. That's important and that's imperative to the process. But now beyond that, I think, knowing how well a contract is written in favor of the publisher or you may help move the needle as to how much you have to negotiate for as well. So I think that also creates a dynamic in terms of the tone you bring to the bargaining table, the asks that you make. And I think it's kind of hard to anticipate because no one contract is necessarily the same, but typically publisher agreements or agreements that are issued by a publisher are going to be more publisher friendly. That I think that's the general norm. But some of the terms in there may warrant revision that other publishers necessarily have those types of same or those similar types of clauses that necessarily don't need those types of changes. Either way, it's a matter of reading, scrutinizing, asking the questions, and most importantly, know that especially if you have legal representation, your rights are very important. So exercising those rights, protecting those rights are above all probably one of the most important talking points in the process of a negotiation. And kind of like a little bit of like an honorable mention, the more you negotiate, the better you're going to get at it. I think it's hard to be exceptional from the onset, especially if you've never negotiated anything before. But the more you do it, the better you're going to become. So don't be hard on yourself if you felt like it was a failure the first time. Trial and error, that's the name of the game.
I've learned a lot over my years studying contracts, and I've worked with lots of law professionals to educate me on what we should and should not be looking for in contracts. But when I first started out, I was not nearly as much of a shark as I am now. And now I can look at things and find things that need to be changed, the red flags, the things that should worry me or the other people that they are working with in terms of that contract. But it wasn't something that I started out with. I had to learn a lot. And because I had professionals on my side, I was able to gain a lot of knowledge and insight on this to make it easier for me 5 years into the game. One of the things that I've noticed is a lot of people, publisher-wise, will make promises or they will give you certain stipulations that they verbally talk about, but they don't necessarily put in their contract and can't be reinforced later on. So when it comes to creating those contracts, what should we be mindful of in terms of spelling out what each party is responsible for, deadlines, and things like that?
I think ambiguity is very easy to get. It's very easy for ambiguity to happen in a contract, any type of contract. So spelling out anything and everything is imperative. So for example, if you're submitting a manuscript to a publisher, does the original copyright of the manuscript still vest with you if that's spelled out in the contract? what is going to be the advance for a deliverance of a first draft? Is there, if you can't deliver a draft on a specific deadline, is there specific language in the contract that would allow for an extension, or at least some type of reasonable communication with the publisher to work out, after the fact, what the reasonable first deadline would be, or a second deadline, or a third deadline? What representation and warranty is the publisher making, and what representation and warranty is the author, you, making to the table? Are you representing and warranting that you're the copyright owner? Is the publisher representing and warranting that they're going to make certain assents to the contract that are going to be satisfactory and not in conflict with any other contracts? So those types of questions are imperative. Indemnification clauses, super important. That word is so long. I think it's like 10 plus letters to it already. And people see how long it is and like, oh, yeah, I don't have to pay attention to it. No. Indemnification is really important, because what if something arose as a result of the contract between you and the publisher that leads to a breach? Typically, indemnification clauses are unilateral, where one party says, oh, we got this claim for copyright infringement, or we got this claim of breach of contract, or some other legal claim. You, author, are going to indemnify us, aka you're going to handle all the legal work, and we are not going to lift a finger whatsoever. Please don't be quick to agree to those. You agree to a dual indemnity if you have to, but don't be quick to agree to those types of clauses, because do you have deep pockets? If you don't have deep pockets, then you shouldn't be agreeing to indemnification clauses so quickly. And then, of course, understanding what the royalty payouts are going to be, what type of other advances are you going to get. On the point of royalties, are you going to be paid based on net profits? Are you going to be paid based on adjusted gross profits? I agree with getting adjusted gross profits. Never agree to net profits, because odds are you might get 0 cents at the end of the day. This is a big sticking point in movies, where actors who have played these iconic roles still haven't gotten a cent from their roles. One most notably was the actual body, the actor that played Darth Vader under the mask. He agreed to a contract way back when he played Darth Vader in Star Wars, the original one, and obviously got an advance, got paid to do it, but after the fact has still never gotten any additional payment based on net profits, because actually Star Wars never netted positive revenue as a result of it, even though it was a box office sensation. That's because there were so many expenses for taxes and payouts to other priorities, like vendors, other expenses that were imperative before paying the actors. So maybe having a publishing lawyer work with the publisher to negotiate adjusted gross profits for you may be the name of the game as well. So, and I could go on. I mean, termination clauses as well. Would if there's an assignment of copyright ownership, would that revert back to you? If you feel like there's non-performance of an agreement between you and the publisher, could you terminate the agreement and get the manuscript back and shop with another publisher? Credits, I mean, there's a lot to it. So reading each layer and not being quick to glance over it, even if it's 25 pages long, working with a publishing lawyer to really read each line and negotiate something that's going to work favorably for you. That's very, very important there's a lot of important phases in the publishing process, but that is the most important phase of the entire publishing process.
Let's talk a little bit about breach of contract and the termination clause, because one of the things that I see a lot when I'm going through these different contracts on my behalf and just looking at them for my friends to adjust them or show them over to the correct lawyer to help them actually legally go through it and make sure they know what to point out to them, is that the termination clause does not necessarily cover the author getting out of the contract, but rather just the publishing house being able to remove themselves from working with the author. So talk to me a little bit about what we need to know in terms of an adequate termination clause, so that authors, if there is a breach of contract from the publisher, can get out of those contracts.
So I think contract law is state specific. So also I think a factor here is you have to make sure that whatever contract you're negotiating with the publisher, it's important to understand what governing law is going to govern. Is it going to be New York? Is it going to be California? Because that could also weigh into a factor here with respect to termination and non-performance of a contract. But generally speaking, this seems to be a universal norm in any aspect of contracts. Termination could be allowed if there is some type of non-performance of an agreement, or one of the parties cannot satisfy the obligations that are set forth in a contract. KM is right. Publishers will be the one typically to create that unilateral provision of a termination for when they negotiate with authors. So if you're an author, you want also some type of carve out, some provision or protection for you, so that you could reasonably get out of a contract if you feel like the publisher isn't doing their duty. Like, for example, if you feel like the publisher made all these ascents that they would market the heck out of your book and they haven't, that could potentially be, a reasonable or give reason for an author to at least entertain the thought of terminating a contract. Because let's say you signed a 5-book deal with a publisher, and just from book 1, the publisher hasn't done a good job promoting it. Maybe then at that point you want to take the other 4 books and shop with another publisher and take your talents elsewhere. So bringing up, some type of additional clauses within that termination clause that would create a safeguard for the author is important as well. And again, contracts are all about a meeting of the minds. So eventually there's going to have to be some type of agreement between you, the author, and the publisher. And it may be back and forth, and it may be the sticking point that kind of leads to a stalemate. But at the end of the day, it's important to have your rights enforced and protected in some way. One other thing I'll say, though, is sometimes, and maybe this is a nice remedy to the whole termination dispute, there could be a world where you have a cure clause incorporated in a publishing agreement, where let's say one of the parties didn't satisfy their duty. Let's put the onus on the publisher because they're the bad guy, right? The publisher didn't satisfy their duty of marketing well, or they potentially breached a contract because they didn't pay you on time or something else. Cure clauses are kind of like a mitigation tactic that essentially is created to allow the party that has done wrong to make themselves whole and right. So sometimes cure clauses allow for a 30-day window, maybe even more narrow, 15-day window, but reasonably is a 30-day window to say mea culpa, let me fix this, and it's basically like my bad, but written in a more legal fashion. So it's important, I think, to have a clause like that, because maybe that could be a nice mitigation tactic before you just jump into termination, because it could be kind of abrupt and maybe a publisher may take it the wrong way as well. But I think every publishing lawyer that negotiates publishing agreements is going to have a different thought process about something like this. So, maybe if you're watching this and you feel like that could be something worthwhile mentioning or incorporating in a publishing agreement, ask your lawyer. Say, hey, do you think it's worthwhile incorporating this? And if they say no, go kick rocks. Great, then you include that. But if it's worthwhile, why not? It doesn't hurt making the ask. The worst that could happen is the publisher says no, and then you keep fighting until they eventually say yes.
There we go. Now, we've talked a lot about things that we should be mindful of to protect ourselves when it comes to potentially signing these book contracts. And we've kind of talked about more of the red flag side of things. Let's talk a little bit about the green flag side of things. What are some good signs of a contract that will allow us to have a healthy working relationship with the publisher or the party that we are entering into that contract with?
So I think having some type of creative control in the process, publishing wise, is great. I think the fact that you're submitting a manuscript and you're able to have some type of say when it comes to approving cover art or illustrations within a book, or maybe some modifications, essentially working with an editor, you don't want to hand the keys over to the publisher entirely. So I think that being able to work compatibly with a publisher in that way, if there's some type of clause incorporated in the publishing agreement that allows for unified creative control, especially from you, the author, that's wonderful. I think that's really, really important. I think the discussion about intellectual property is important to have here in this type of discussion, because again, we have to ask the question, is the original manuscript still going to vest with you, the author, or is that going to be handed over to the publisher, or is it going to be a joined copyright ownership where you, the author, and the publisher will own the copyright? I still feel like if you have at least some type of copyright ownership stake in the work, I think that's great. So a clause that may include that in your publishing agreement is really, really important to have. Obviously, I mentioned indemnification clauses. If it's a favorable indemnification clause that does not put the onus on you, fantastic, go for it. And then, of course, I think the royalty payout is of particular importance here, as well as everything else related to consideration, what you actually get paid. So if you get a good advance for just submitting the manuscript, that's great. If you get a good payout once the book is completed, that's also great as well. And if your royalty share is going to be really good, where you're getting, let's say 30% or 35% for every unit sold, wonderful. Then that means that you're getting at least a good payout. And you're not getting, cut out of, significant sum of money. So I think that having those types of favorable clauses are going to lead to I think a really really good happy ending for both parties. But yeah, it's I think not going to get there so easily. I don't think it's going to happen automatically. I think that will more likely than not happen because you're fiercely advocating for yourself as an author to get to that point. Once you get to that point, then you can have closure and sit back and watch your work of art come to full fruition.
And if you are prepared to be negotiating your contract, you have to make sure that you understand the industry, how it works, how the pay structure works, how you can be fighting for your rights and making sure that you protect yourself. And we've got videos on all of those things here on the channel. So make sure you hit that subscribe notification bell and you check out the videos that we will link down below so that you can go through the playlist to make sure you are advocating for your rights as easily and as successfully as possible, making sure, of course, that you are bringing in your legal counsel before you sign any documentation to work with any entity within this industry. Tony, final thoughts on book contracts and things we should be mindful of?
Just remember again that contracts are, frankly, they're a complicated process, but it's all going to boil down to how compatible you can be with the publisher or their attorneys. And also having good legal representation is also imperative in this process. And I think I kind of alluded to it with the whole meeting of the minds discussion. That's the general essence, the philosophy of contract law. But part of having a meeting of the minds also involves the tenor that is brought to the table. So if you're abrasive and you're hostile, that's probably not going to lead to a really good outcome. But if you come with an open spirit and really with like a yearning that you really want to see something good come out of this, the odds of having your clauses accepted or at least entertained are going to be better than if you just go in like gangbusters and saying, oh, I want this demand, I want that demand, and you do it in a very hostile fashion. So compatibility, I think, is also very important in this whole process.
Being willing to negotiate is very, very instrumental in your success in making sure you have the book contract that you want. Tony, this has been a fantastic conversation, and I know people are going to have lots of questions because this is something we have a lot of questions about. So we will be paying attention to the comments down below. Feel free to drop your questions, but you can also reach out to Tony on his social media where he answers questions and drops content all the time to help you level up to stay safe in your adventures on social media, inside of the business world and inside of the book world. So Tony, where can everybody find you online?
You can follow me on Instagram and TikTok at the IP Professor, where I discuss all things intellectual property. I've talked about intellectual property in every context, whether it's pop culture, movies, television shows, what have you, even evergreen topics. So feel free to check out my content. You can drop a comment and engage with me in the discussion board. And you can also reach out to me in the DMs, and I'm happy to answer any questions you have.
It's incredibly important to make sure before you sign any legal documentation that you have a professional lawyer look this over. Your agent does not count as a professional publishing lawyer. You do not have the ability to go to just any lawyer. You need somebody who understands entertainment and the publishing industry. So be sure that you do your research and get somebody on your team before you sign anything, because once you sign a legally binding document, it is what it is. Now, if you've got questions on this, drop those down below and make sure you hit that subscribe and notification bell, because Tony has other episodes here on the channel where we're breaking down things like your book's copyright and other legal matters to make sure that you are protected inside of the publishing and writing industry before you step into something that could be a little on the messy side. Drop the questions down below. We'll be continuing to have our lawyers back to have conversations just like this on the channel, and we drop daily videos to help you level up both in the writing and the reading world. I'll see you in the next episode.